All right. So welcome back to our Bressler, Amory, and Ross's continuing webinar series that has turned into the only time where we get human interaction, virtually at least. And this week we are talking about coronavirus and contracts. Obviously, some of these topics you have been touched on prior versions or prior series. However, the law is developing. Lawsuits are filed, almost weekly. I was reading an article this morning on some of the topics that we're going to talk about today. So the areas of law are developing. These issues are very, pressing in this unique time, and we thought it would be a good opportunity to go for a deeper dive into contract non-performance and then touch on some of the major issues with real estate, commercial leases and other transactions like you're seeing with issues with retail and other stores that are now closed due to the various government actions and the COVID-19 crisis. So I was reminded that I am supposed to give a disclosure that this is not legal advice and this does not constitute attorney-client relationship. We're just presenting on the issues. We're happy to have attorney-client relationships with everybody, but right now we are just trying to wow everybody with our brilliance. So I have a great panel today. We have a great panel that we put together here, and I'm just going to go from left to right on my screen, so it might not be left to right on your screen, but we have Mike Ostrowski here. He is the chair of our real estate practice and a senior member of the corporate and commercial transactions team. He's going to be speaking about real estate and some lending issues. I have Karen Murphy with us. She's a principal and member of our real estate environmental groups. She's going to be talking about the lease issues I referenced. And Ron Campione, who actually is going to speak first, talking about some of our contractual issues. And Ron is a principal in our commercial litigation group and our franchise group. So we'll start with litigation and then we'll move into transactional work. Next week, we're going to change it up a little bit. Some of our litigators were chomping at the bit because they love hearing themselves talk more than me, and they wanted to do a trial techniques presentation. So we are taking a little bit, I think we'll weave in some of the COVID issues there, but it's going to be more traditional, just learning from some of our really experienced litigators, some of the techniques that they use in the various types of cases that they've tried. And that will be next Wednesday, same time, same place. And with that, we'll get started. We're going to talk about a handful of different items. We're going to talk about contracts, real estate, commercial leases. And first up, we're going to throw it over to Ron. And Ron, obviously, force majeure has been the primary area where the contractual issues have arisen. And can you give everybody a little bit of background of what that is and how it comes into play with the COVID-19 crisis?
Sure, thanks, Nick. And we can just start with the next screen. What we're going to discuss in the first part of this webinar is what is a force majeure clause? How can a party use this clause, or do they want to use this clause, and what does it mean to me as a contracting party that may have an issue in performing what I was obligated to do under my contract? Well, I'm going to touch upon, and Mike's going to get into it further, about what if your contract doesn't include a force majeure clause, but you're still having difficulty in performing under that contract, or there's been some instance or impediment that has delayed your performance of that contract. And how do I invoke or how do I defend against a force majeure clause? And then we'll close it out with a recent case that just came out by decision on Monday in the Southern District of New York involving a franchise and the invoking of a force majeure clause to stop a termination of their franchise. So let's get started there. What is a force majeure? You can flip, Nick. Next slide. Okay, force majeure literally translated means a superior force. And what does that mean? What are we talking about? It's an occurrence that happens that is unforeseeable between the contracting parties to an agreement and beyond their control. And I'll start with a hypothetical, and it's a very simple hypothetical. And let's say your company manufactures, sells, and distributes this one-of-a-kind widget. And this widget can only be purchased from your company, and you're the only supplier in the entire world. And as that widget is getting ready to ship, it's sitting in your warehouse, and there's 100,000 of them. Lightning strikes your warehouse and burns it down. That's an unforeseen event that is going to impede your ability to deliver and distribute those widgets, and will probably excuse you from performing under that contract. Okay, what it does, what the force majeure clause does, is it limits the amount of damage you could be liable for, or gives you a delay or an excuse in performing when there's this unforeseen event that occurs. What we're seeing now since March is that COVID-19 might be that lightning strike. It's all going to be language specific as what is included in these agreements, what happened after the pandemic hit the United States. I mean, globally, the World Health Organization declared COVID-19 a pandemic in January. The United States reacted in March. Governors started shutting down states. They executed stay-at-home orders or shelters in place. The action by the government may, in some instances, depending on how the definition in an agreement is written, constitute a civil action that will excuse performance under a contract. You also have to think about the future going forward in entering into contracts now. What do the force majeure clauses say in those contracts? How are they going to apply when you have the knowledge that you may have some interruption in performing your obligations under this contract? Next slide, Nick. Okay, so what do you have to do? Is this underlying event, the COVID-19, the government shutdown orders, are they affecting your ability to perform under this contract? That's the question that businesses have to ask themselves. What are the alternatives? One of the things the cases always look at is there an alternative to performing? So if I had to supply a widget and I'm unable to supply this specific widget because I made it, but I could go out and I could buy it from another supplier and perform under my contract. Well, that's an alternative that a court would look at and say, well, you weren't completely stopped from performing under the contract. You may have lost profit by buying it from someone else. However, you still could have performed. These are the type of analysis that courts look at when they look at these force majeure arguments. They're very fact specific. They look at the specific contractual language. Most courts narrowly interpret that language, or traditionally they narrowly interpreted that language. As we're going to see when we discuss the Southern District case, New York, who traditionally interpreted force majeure clauses very narrowly at the specific language used as the agreement between the parties, may have expanded or opened up their interpretation a little bit. Ask yourself, or your business needs to ask itself, do we want to invoke this clause and not perform or look for an excuse or delay? Or should we try to renegotiate the contract? Maybe we can supply it at a later date. Maybe we can make payment at a later date. What's the business relationship like? And that leads us to ask, is this inability for the company to perform permanent or is it temporary? Need to know the jurisdiction of that governs, or the law that governs your contract. If It's in the United States. Domestic law generally, as I said, they take a narrow approach in interpreting the language in these contracts. International contracts, on the other hand, sometimes look to the International Chamber of Commerce rules. They look to the Convention on the Sale of Goods, all of which have their own definitions of force majeure, and usually incorporate into that, and Mike will talk about this standard, a standard of impracticability. Internationally, we've seen a lot of these contracts that include force majeure or have interpreted the force majeure language. In Italy, for example, they have a civil code, much like our Uniform Commercial Code. And I use Italy as an example because they were one of the hardest hit countries of the COVID pandemic. That excuses a party from performing under a contract. So you need to know the jurisdiction and the choice of law that's applicable to your contract. Next slide, Nick. Okay, so we were using this sample. This is a real force majeure clause that was included in a contract in an international franchise agreement.
And Ron, real quick, we will be circulating all the materials. So I know there's a lot of words on some of these, but we wanted to put a couple of the real examples in front of people to see. But we will be circulating a copy of the presentation when we're done.
Right. Thanks, Nick.
No problem.
So, COVID-19, what is it? It's a virus. It's can be described as an epidemic. It can be described as a pandemic. In this sample force majeure clause, we have that language. Starting off with, attorneys, I think, and business people always refer to a force majeure clause as the act of God clause. And, the old joke, if you want to hear God laugh, just tell him what your plans are. So force majeure clauses are drafted in order to plan against an unforeseen event, right? Something like a strike, a lockout, war, terrorist attacks, riots. And in this case, we have the language epidemic. Will COVID-19 fit into that epidemic language? We have yet to see, and cases have been filed, and we will see how courts interpret that language. In this specific force majeure clause, though, and I believe it was because of where the parties were situated in this agreement, governmental action was considered by the parties. So any shutdown by the government was considered. So that would come into play, especially now in the United States with government shutdowns. And if you're a non-essential business, you'd probably have a good argument to rely upon this provision of this force majeure clause. Next slide, Nick. All right, so you're looking through your contract and you say, oh boy, I don't have a force majeure clause in my contract. What do I do? And Mike, I'm not going to go too far on this, but there are several doctrines out there in contract law that may excuse your performance, and they include impossibility, impracticability, and frustration of purpose. They basically say that something has happened that makes it either impossible or not practicable for me to perform under this contract. Those concepts of contract law are built into most of the states' adoption of the Uniform Commercial Code. So there is another fallback for those parties who are experiencing difficulty as a result of COVID-19 and the government shutdowns. Next slide. So the decisions that the company has to make. Do you want to invoke a force majeure clause? Maybe based on your relationship. It's a long-standing relationship. There's other contracts involved. You may want to go back to the negotiation table and say, listen, we can't get it done in this time period. We're going to try and get it done if you can extend for us. Maybe negotiation is the way to go. Understand what your options are. Very important for you, if there's a force majeure clause, to look at the notice requirements in your contract. It may say Notice of the inability to perform as a result of force majeure requires you to send a letter to John Doe at this address via certified and regular mail, and you need to comply with all of those notice requirements. You also need to do a risk assessment. What happens if we invoke the force majeure clause and we're unsuccessful and we're held liable for breach of contract damages? And lastly, again, going back to the negotiation table, will the parties agree to terminate? Will they agree to extend? Can we partly perform and delay performance to another date? Next. And after you decide how you want to handle this, you need to prepare. And this is just a simple instruction that we give to all litigation clients, which is you have to save everything. All documents and communications, electronic, paper, text messages, emails, everything. Review your current contracts, review what the law is, and in some cases, you may be the recipient of an excuse to perform or an application of a force majeure clause. You need to know how to deal with that with your upstream supplier so that your downstream buyer contract is protected. In our research since March 15th, we've come across probably about 10 cases dealing with COVID in the state and federal courts. As Nick mentioned earlier, an article came out last night in Law 360 where there's been 168 new case filings between March 2nd and May 2nd, just in the federal courts relating to breach of contract. We don't know how much further that breaks down into contracts that involve the application of a force majeure clause. You'll get this in the handouts. It's just a quick summary of the cases that are out there. And the case that I'd like to discuss to conclude my portion of the webinar is a new case that was filed in the Southern District of New York in April of 2020. And it involves a company called ETW LLC, not Pacific ETW, just ETW, and Kidzania. Kidzania operates a franchise in which they build amusement parks that allow kids to participate as business people. So they can be doctors, they can be engineers, they can be race car drivers, and they go to these amusement parks and they can have fun being a professional for the day. So ETW was granted the franchise rights for the United States, the entire United States. They had one amusement park built in Texas, and due to construction delays and governmental delays, they didn't open until November of 2019. And at that point, they had been behind in some of their royalty payments to the franchisor Kidzania. Now, I just want to, just so you know, this is a franchise agreement that applies New York law as its choice of law, but requires any dispute resolution in international arbitration. So ETW continues to operate, and not to get into the complex facts regarding the financing here, there were some issues with obtaining financing. They went back to the franchisor, requested additional time to make payments of their royalties. That was agreed to. Fast forward, the parties get into an argument, and the franchisor sends a termination notice. Well, the franchisee E2W defends the non-payment of the royalty fees on COVID-19 and the force majeure clause. And Nick, if you could go to the next slide. E2W went into court seeking a preliminary injunction and asking the court to look at the force majeure clause because of the government shutdown. They're unable to operate their amusement park, therefore unable to generate any income. And therefore, they're unable to make a payment that they agreed to make prior to the COVID-19 breakout. So obviously the franchisor came back and said, no, you're still obligated to pay us because You had this obligation prior to COVID-19. Now, going back a couple of minutes, this was a case that applied New York law. You would expect the court to look at this force majeure clause and narrowly interpret it. And it's despite the use of the word governmental orders or regulations, it doesn't really address pandemics, sicknesses, illnesses. But it does say government imposed restrictions. On Monday, the court issued, you can fast forward, you can go forward, Nick. One more. On Monday, the court entered an order granting the preliminary injunction against the franchisor Kidzania and enjoining them from terminating the franchise agreement and taking any actions that would interfere with the franchisee's operations of the business. So, contrary to what we've learned about New York and its narrow interpretation of force majeure clauses, in this case, it seems like the judge broadly interpreted that force majeure clause. And as we know from injunctive application, one of the elements that you have to meet is that a likelihood of success on the merits. So in granting this application, the judge gave some weight to the plaintiff's argument and to that force majeure clause and enjoined the franchisor from terminating their franchise agreement. Okay, any questions?
So Ron, I just had a couple quick observations here. Obviously, it seems that that's a vast expansion of what we had traditionally seen, right?
I don't know about vast, Nick, but it is an expansion. I think, contrary to other cases in which force majeure clauses are very narrowly interpreted, looking at the specific language that the parties agreed to, the Southern District went a little bit further than that, just from my reading of that force majeure clause.
Yeah, and I think that this circumstance that we are in right now, I think you may want to tread a little bit more lightly if you're really trying to bind somebody.
I agree with that. You probably want to be careful that, although the language may not be specific as saying pandemic, epidemic, illness, that courts are going to find a way, knowing that businesses have been shut down by governmental authority, to invoke those clauses.
Right. And my other observation was that sounds like the worst theme park ever anyway. So I'm just trying to imagine getting my kids to come on and let's go be an accountant. I'm assuming that the auto racing piece was a way bigger.
Probably a bigger draw, yeah.
Yeah. Dress up and go to work. We're going to the theme park. All right. Well, thank you very, very much, Ron, for that presentation. And Mike, obviously, we touched on some of the similar issues because we're dealing with contracts when we're talking about real estate and lending. So let's do a little bit of a deeper dive into how real estate contracts have been impacted by the COVID crisis, and what are you seeing?
Well, thanks, Nick. First of all, it looks like I'm the old man of this panel, so I don't know if that's a good or bad thing. Maybe I've seen more things, but I certainly have not seen anything like the COVID-19 pandemic. And let me just apologize at the outset for my voice. It seems to be a little affected by allergies that I've had, and it's gotten worse in the 6 or 7 weeks that I've been home. I'm not sure if that's related to the people that I'm quarantining with, or maybe I'm just allergic to emptying the dishwasher. I'm not sure. But in any event, yeah, real estate obviously is an area that's heavily affected by COVID-19. And that's both in the transactional area with contract provisions, how people want to extricate themselves from their contracts if they need to, which we'll talk about, And a little bit later, we'll talk about how it affects lending. Institutional lenders, how they lend now during the pandemic, what factors do they take into consideration, and how it might affect performance of contracts. So force majeure, and let me just say that Ron did a great job on explaining force majeure, and I'm just going to touch upon it a little bit and get into some other contract principles. But in real estate contracts, any of the ones that we're talking about now, be it force majeure or the other common law principles that we'll discuss, they're kind of last bites at the apple. Because typically in a real estate contract, there are contingencies. So if you sign a commercial real estate contract as a buyer, you will typically have something called a due diligence clause, which permits you to do investigations about the property that you're buying and deciding whether or not to proceed at the end of that contingency period. You may also have a financing contingency. Financing contingency gives you the right to obtain financing within a period of time, and if you don't, you have the right to cancel the contract, similar to the due diligence clause. What we're now talking about are situations where those contingencies have been satisfied, so that you're through the due diligence portion of the contract, you've gotten your financing, or have backed out if you didn't. And now, what other ways are there that I can protect myself in the real estate contract if I'm going to go ahead and purchase or sell? So the first provision, which is in most commercial real estate contracts, is the force majeure, as Ron described. It's really now becoming a part of our lexicon because of COVID-19. You know, it's always been a provision in these contracts, but clearly it's become much more popular for a party to rely upon because of COVID-19. And as Ron said, it's very specific to the contract. There may be a very broad and vague and overall force majeure provision, or there may be one that is specific to particular parts of performance. So the first thing that a court will do in a real estate deal, it will look at the language of the force majeure provision in the contract and determine whether it applies. Obviously, a pandemic that we are now in could certainly, as Ron said, would certainly be interpreted as being an event unforeseen and an act of God. So it falls within the force majeure category. Whether it applies to that particular contract and whether a client can rely upon it is very fact specific. And also it depends on the language that's actually in the contract. There are two recent cases, the two big cases in the real estate area that have been filed recently. One is a Texas case where a company signed a contract to buy a Houston-based dine-in theater. And after their contingencies were met, they sought to cancel the contract literally days before the closing, saying, and it was in March, saying that based upon the status in the world today, I cannot buy a Houston-based dine-in theater because of the nature of that business in that piece of real estate. And naturally, the seller said, we're ready to go. And suit was filed by the seller to force the buyer to perform. And it's a pending case. It's fairly new. Initial papers were filed. And it'll be interesting to see how the court deals with this, because a lot of eyes from the rest of the country are on this case because it's a pretty standard force majeure matter. The other case is in California, and it's the purchase of a piece of property from ExxonMobil. And the buyer sought additional time based upon the force majeure clause. All the contingencies had been met. It was due to close the end of March, and the buyer sought an extension. The seller, in responding to that, not only said no, but they declared a termination of the contract and told the buyer, you can no longer purchase the property. And one of the reasons I think that they probably did that was because they saw that based upon the changes that COVID has affected around the world and in their particular part of the world, they didn't want to go ahead and proceed with the contract. They didn't want to close title and convey. So now the buyer has been forced to seek relief, forcing the seller to go ahead and consummate the sale. So those are two matters that everyone is looking at to see how courts come down with respect to the force majeure aspect. Now, there are other things that Ron alluded to that are not usual provisions written into the contracts. They're common law provisions, but they are very much in play, particularly now during the pandemic. The first really is one of my favorites, frustration of purpose. And what that means is it is not so much related to your ability to perform the contract. It is rather related to the value of the performance. If the value has been significantly affected, thereby frustrating the reason why you want to make this purchase, this doctrine may apply. So for instance, if you're going to buy a deli, and let's make it the Milburn Deli, one of my favorite restaurants in the world. If you want to buy that and you want to operate the deli within that piece of real estate, you may make the argument that with the advent of the COVID pandemic, the value of that has been affected. The business model of a deli like the Milburn Deli is that it's a small physical space. People are cramped into that space every day. You take a number to be waited upon. They're waiting outside to get in. The density is such that you can't move. It's a business model that in the world of COVID may just not work anymore. So the argument would be, am I really getting the value that I thought I was when I signed the contract? I don't think I am, because the world has changed. And this model, this business model, will just no longer work.
Well, Mike, I hope they don't make that argument in Morristown.
Sums up what a frustration.
I hope they don't make that argument in Morristown.
Yes, we're supposed to get a takeout Milburn Deli in Morristown, and I've been waiting for that. Hopefully it comes soon, and that it's not somehow prevented from opening. But that's what frustration of purpose is. And by the way, I think it's important to understand that all of these doctrines, they're hard sells to a court. You know, the court has to be convinced that all of the elements are met. So for instance, in the Milburn Deli example that I described, the court might say, well, okay, you're right. That business model no longer is the same as it was before the pandemic, but there are actions that can be taken to mitigate against the drop in value to you, so that it's not going to make it something that you shouldn't have to finish the contract, purchase the property, and it shouldn't totally frustrate the purpose for which you made the deal. There are ways to affect that. So the burden is on the person invoking this concept. It's a difficult one. And the next one,
Mike, right before you get to the next concept, let me give the first COE code, which is frustration.
yes,
And that's in the notes.
I think we're all a little frustrated after these weeks.
I felt like it was a topical one.
Right. Well done. The next one is impracticability or impossibility of performance. And I think it's safe to say that the word impracticability is probably not one that you're ever going to use in your life, other than if you're trying to make this defense. It's just one of those great legalese words. And it really is an impossibility of performance concept. Impracticability is one step down from that. But an impossibility argument says that objectively, it's impossible for me to complete this contract and carry out my obligations. Why might that be? Well, I may be buying a building that is no longer permitted to operate due to some federal law, some state regulation, some local zoning ordinance. I can no longer operate this piece of property the way that I wanted to, and therefore it's impossible for me to perform. Maybe it's a manufacturing plant that has now been deemed to be, because of societal changes and changes due to a pandemic, that cannot, those particular functions can't be carried out in that piece of real estate. So I make the argument that I can no longer perform and shouldn't be forced to perform. It's a very difficult burden because courts are going to say, well, okay, that may be true, but you can put it to some other use. It may cost you more money, but that doesn't give you the right to get out of the contract. So that's a difficult burden, and that's a common law concept that typically you will not find in a contract. The next one is conditions precedent. And what we're finding now, and it's really always been around a bit in the world of real estate, is that contracts will have provisions, depending on the type of property that you're buying, that will require that certain conditions exist in order for you to complete the purchase. So for instance, if you're looking to purchase an office building or a multifamily apartment building, you put in the condition that there must be a certain percentage occupancy and a certain dollar figure of rental income that is received in order for you to have to complete the purchase. Now that obviously is going to be changing as we move forward in the time of COVID-19, but it's certainly going to become much more common in contracts because people are going to want to make sure that the bargain they initially met is still appropriate. And these conditions have to be met in order for my obligation as a buyer to have to proceed. So those are some common law concepts. The last one, which I'm going to kind of call the catch-all, is the material adverse change. And this relates to really just as its title would indicate. If there has been some material adverse change in the circumstances surrounding the transaction, then I would assert this as a defense to my need to complete the transaction. And it's actually probably more appropriate in the area of a merger or an acquisition on the corporate side, where you might say that there's been adverse circumstances that have affected the target company. That target company can no longer produce as much as it had been. It can no longer produce the revenue that it had been. But it also does apply in the real estate area. And the big case on this is a Delaware case called the Acorn case, Akorn. And what that case stands for is that if it is a specific material change as to the business or building being sold, then that is on the seller. But if it is a systematic change in the society and what's going on around us, like a pandemic, then that becomes a buyer defense. And the buyer would say, hey, we have a material adverse change going on in the world, and we can no longer proceed to buy the property. Now, again, this is very difficult because although it may change the value and it may change the specific circumstances for which you were going to make the purchase, it's difficult to convince the court that you no longer have the obligation to complete the purchase. So those are some of the contractual provisions that we are now taking a hard look at in the real estate area.
And Mike, next we're going to talk about some of the lending and loan payment financing issues that you've been seeing.
Yes, correct. So now you're an institutional lender and you've been making real estate loans for many years, and now the COVID pandemic hits. How does this affect you? So the typical way that an institutional lender will decide how and when to make a loan, they'll look at two main things. Number one, they will look at the ability of the borrower to repay the loan, and that's based on credit and income. They'll look at that, and then they will also look, secondly, at the collateral, the real estate that's being purchased with the loan. And they will establish what's called an LTV, a loan to value. So that if the value of the building is $1 million and they're willing to lend 80% of that value, so the LTV is 80%, they must get an appraisal of that property for $800,000. And if they don't, they won't make the loan. So as you can imagine, now with COVID having hit and the pandemic in place, no one really knows what's going to happen with values of buildings going on into the future. No one knows how it's going to affect it. Banks are really not sure what's going to happen in the future. I can tell you that what they're doing is they are taking these appraisals that they're now getting and they are looking at them in a lens that would try to include a look ahead to the next year and to see what that value on that real estate is going to be. No one knows. No, and as a result of that uncertainty, well, what a lot of banks are doing is they are limiting their new loans to existing customers. So that if they have a known quantity, a company that's been with them, buildings that they're familiar with, they will go ahead and refinance those loans or make new loans to that company for other purchases. But for a new company to go to a bank now, and they would have to do a complete credit check and develop familiarity with a new company and look at their proposed purchase, it's difficult because banks are nervous. They really don't know what's going to happen with the real estate market, and it affects people that are part of these contracts that seek financing. So obviously, a much easier way to extricate yourself from a real estate contract is if there's a financing contingency in it, and I would obviously, anybody that came to me now, I would insist that there be one, if it will affect whether they can get that financing. It's easier to say to a seller, I could not get my mortgage from my institutional lender because of what's going on out there in the COVID world. And I then cancel the contract under the mortgage contingency. Now, what are methods of valuation? What do banks use as to how they value buildings, and what do appraisers use to value it? One way is comparables. They look at other similarly situated buildings to determine what the value is of those buildings similarly situated, and how do I compare it to the building that I'm being asked to value? What are ways that they can determine values of those comparables? Well, the easiest way is a deed price, because a deed price will show a market value. So if a property within the same area as a building that they're appraising had a deed price of $2 million, then that's a pretty good indicator of fair market value, and they may want to attach it to their target appraised property. The problem in a COVID pandemic is that $2 million number, based upon a deed price before the pandemic hit, may go out the window. And that's the problem. The income approach is the other way that banks will value properties, and that's based on how much revenue, how much income the building throws off. And in these situations, we're talking about office buildings, we're talking about multifamily tenanted buildings. Again, they look at that, and that helps them come to a value of the property. But there may be numbers that a building was throwing off in terms of value before the pandemic struck that are just no longer happening. People aren't paying rent. It's a very difficult thing right now for banks to assess. People, as I said, people may not be paying rent. The business being operated in the building may have completely slowed down, so that the revenue generated is drastically reduced. These are all issues that an institutional lender needs to consider before deciding whether to issue a commitment. And that's why I say that it helps if they know the borrower by past experience. It helps if they have a credit history with that borrower, because if they do, they'll feel a lot more comfortable in making the loan. Now, one of the things that I'm sure you've all read about is what happens to the borrower under loans when they can't make payments due to the pandemic. Their revenues are down, their businesses are being slaughtered. How do they make their mortgage payments? Can you just go to your bank and say, I can't make payments over the next few months? I think the thing that banks are trying to do, and bank clients of mine are doing this a lot, is they're deferring mortgage payments. So they're saying to borrowers, look, we understand what's going on. We're going through it together. We will defer mortgage payments for the next few months to allow you to hopefully get yourself back on your feet and get yourself through the pandemic. And then we'll take those deferred payments and we'll stretch them out over a particular period of time for future monthly payments. But at least you don't have to go out of pocket for the mortgage payments during these crunch months where the pandemic has really affected your ability negatively to make the payments. And Karen will be talking about similar situations between landlords and tenants when she talks about leases. And of course, it requires an analysis of the particular borrower as well as to whether they'll give a deferral. Again, known quantities are always better. Now, one thing I wanted to mention before I turn it over to Karen to talk about leases is the Paycheck Protection Plan. I know you've all read about that. It's a federal legislation that helps small businesses to meet payroll and combat the negative effects that the pandemic has had on their businesses. Billions and billions of dollars have been made available to small businesses. They've taken the monies, which are loans payable over 2 years at a 1% interest rate. Some of the loan is forgivable based upon what you use the money for. You know, I read recently where it's kind of like building a plane as you fly it, because there are no preset rules as to how this works, and they're coming up with new interim rules and frequently asked questions, and it's literally changing every day. And recipients of the loan, don't quite know what to do about what's forgivable and what isn't. So it's really a learning process as we go along, but it has been, the SBA is calling it a major success. So they believe that it's had the desired impact, even though there have been some large public companies that probably weren't entitled to it, who have returned the monies. We're going to see as we go along what additional factors are going to be built in to the PPP and how it might affect other small businesses. Any questions?
Let's move on to Karen. We're running a little bit late on time. We have about 10 minutes late, and we do have one question in the queue. But if we can get to that, we will. If not, we will circle back afterwards and try to connect. So Karen, talking about, as alluded to, we're going to talk about some commercial lease issues.
Sure. Thanks, Nick. Thanks, Mike. There's no doubt that this pandemic has hit landlords and tenants very hard in the commercial leasing space. We've been getting a lot of inquiries from both landlords and tenants who are seeking advice as to their respective rights and obligations under a commercial lease. So we're going to take a look at some of those basic issues that are in a commercial lease and how you might go about interpreting those and what rights and obligations both tenants and landlords have in light of this pandemic. The first point is that in a commercial setting, unlike residential leases, there are few, if any, statutory protections for commercial tenants and landlords. So your lease is going to govern all of your rights and obligations, not statutes or common law for the most part. As a result, it's really important to do a careful review of your lease, to take a look at your rent provisions. Force majeure provisions, as Ron discussed, have taken on a real significant importance. Any affirmative covenants in your lease, and certainly the default provision, so that you understand the ramifications if you are in default under your lease. So let's talk about payment of rent. Typically, in most leases, the payment of rent is what we call an independent obligation, and that means it survives regardless of other provisions in the lease. In fact, many force majeure provisions in a lease often have an express carve-out for the payment of rent. For example, a typical force majeure provision might tack on the end of it a sentence that reads, "Under no circumstances will tenant be excused from the payment of rent due to force majeure events." So those type of express statements in a force majeure provision and scattered throughout your lease are very difficult to overcome through common law or other statutory provisions. And as Mike alluded to, these are hard sells in a litigation context when you have express statements like that in your lease. Most commercial leases will also contain language that there's no right to offset or abate rent due to the failure of the landlord to provide services or even to provide access to a building. So absent any express provisions in lease that permit a tenant to hold rent, the tenant is usually liable to pay rent. And as I said, even where access to a premises has been prohibited. Similarly, payment of common area maintenance, CAM, utilities, real estate taxes, all those additional rent obligations. Some leases will allow abatement of additional rent if services have been interrupted for a prolonged period of time, but it really depends on your particular lease provisions. Other leases will make additional rent payments an obligation absent any other circumstances. Leases can also contain express and implied, they always contain implied covenants. They often contain express covenants, one of them being the covenant of quiet enjoyment. And what this means is that so long as the tenant is not in default, the tenant is entitled to quiet enjoyment, which means there can be no interference with the use or occupancy of the premises. Each state interprets quiet enjoyment differently. So, for example, many states require there to be a wrongful act on behalf of the landlord in order to find that there is a breach of the covenant of quiet enjoyment. Also, even if you can demonstrate that there's been a breach, as I said, obligations like rent and other monetary obligations in the lease are often independent obligations. So they survive regardless of whether there's been a breach by a landlord. It's possible that some of these covenants may be invoked in litigation if you can show that the landlord either voluntarily prohibited access to a building absent some governmental order, and that restriction on access was unreasonable. Otherwise, it likely is a tough argument to make. We also recommend to our tenants that they check their insurance provisions. Check whether you have coverage under a commercial general liability policy, rent loss policy, or business interruption policy. Although they typically are not going to cover situations like a pandemic, they should be reviewed carefully to see if there may be coverage that could provide you with some protection. So what should a tenant do if a lease is not helpful? Just the next slide, Nick. First and foremost, you should be communicating with your landlord. Be upfront and frank about your situation. You also need to be prepared to show documentation if you are claiming a financial hardship from payment of rent. Expect that your landlord may ask you directly, have you received a PPP or other type of stimulus financing in the last few months? Landlords are aware that a portion of that can be used towards rent, so they may ask you if you've received any of type of that funding. You can request a few types of rent concessions from your landlord. These would all be voluntary concessions from the landlord if you have these type of strict independent obligation to pay rent in your lease. What we've been seeing some tenants asking for is a deferral of rent, and that would be similar to a mortgage deferral that Mike described, where you defer for a period, maybe a couple of months, and then the entire amount is due when that deferral period ends. We've also seen tenants asking for a partial waiver of rent or a partial waiver of CAM charges. We've heard of something called extend and blend, which means you can ask your landlord to extend the term of your lease for a specific number of months, and then the landlord will forego rent on the instant, and then blend that rental payments, the missed payments, over the remainder of your lease term. You should also look at things in your lease like an early termination clause. Consider whether if you have an early termination right, it might be better to terminate your lease until your operations resume under normal circumstances and look for a new space, particular instances where you have no access to a premises. Consider whether you have whether the lease is up for renewal. This may give you some leverage in negotiating with your landlord. If you've been a good tenant and they'd like you to stay and your lease is up for renewal in the next 6 to 12 months, you may want to use this opportunity to try to negotiate some short-term rent concessions with your landlord. And then finally, check the executive orders in your applicable state to see if there are any rent relief concessions coming out on the executive side. In New Jersey, there are some, there's an executive order allowing a security deposit to be used for the payment of rent. That only applies in a residential setting, though. So you have to carefully review the executive orders. New York has issued some more lenient guidance that also applies to commercial settings as well. I'll just quickly go through a landlord's perspective. Landlords are feeling the same type of crunch as tenants. Landlords keep just a fraction of rent. They often have financing obligations of their own. They're not looking to have empty buildings. So a landlord in particular, one that may have received PPP or other stimulus funding within the last month, may be willing to pass that savings along to tenants and provide some rent relief. And landlords are also aware that right now the eviction process has been stalled, either by the court closures or by executive order. In New York, the executive orders have imposed a moratorium on both residential and commercial evictions. It's been extended until August 20th. So even if you have a tenant, as a landlord, if you have a tenant who's not paying rent, they're aware that there's no judicial proceeding right now that can remove that tenant from the premises. So the summary of actions to take in this pandemic would be: review your lease carefully. You really need to take a look at the provisions in your lease that you might have glanced over on other occasions as boilerplate have really come into play now. Things like force majeure and your default provisions, your rent obligations. Stay in communication with your landlord, or if you're a landlord, stay in communication with your tenant. You need to review your insurance to see if there's any relief in your insurance that might help with rent. And then lastly, you have to be flexible and a little bit creative in negotiating with your landlord, because most commercial leases are fairly narrowly construed and contain some of these onerous rent provisions. So the concessions you're going to obtain from a landlord are likely going to be voluntary concessions. For that reason, it's a good idea to remain flexible and reasonable in those requests. And that's all I have.
Awesome. Thank you, Karen. And our final CLE code is impossibility. It's in the fuse notes on the right-hand side there. So both codes there, frustration and impossibility. Thank you, Mike, Karen, and Ron, for your presentations today. Next week, we will be talking about trial techniques with a number of our seasoned litigators. And thanks, everybody, for joining us today.
Thank you. Have a good week.
Thanks.
Thank you.